talked about death earlier, ang pagpanaw ng isang batikang kompositor na si Boji Dasig. Ibinalita po sa atin yan ni Ronnie Laigo ng balita. Pero still speaking about death, what happens if a petitioner dies on the petition? And we're going to be talking about that right about now sa ating American Dream.
This American Dream segment is brought to you by Aquino & Lowe Law Firm, answering your immigration questions.
Attorney Allison Aquino, welcome back to Kababayan LA. Good to see you.
Good seeing you, Janelle.
All right, let's talk about this. Not a good topic, a little sad. When a petitioner dies and the petition is still pending, what happens?
It is unfortunate and a sad situation, but unfortunately with Filipinos, this is a common situation.
Because the wait is too long.
Because the wait is so long. About 2.5 years ago, back in October of 2009, there was a new law that fixed the situation, which the situation before the law was that when a petitioner passes away, the petition also becomes null and void and no longer valid. So about 2.5 years ago, there was this new law, the DHS Appropriations Act, which significantly changed that. And now that it's been about 2.5 years later, we are able to see how immigration has implemented this law, how the embassies are implementing this law, and now able to see more the benefits that this new law has created.
So can you explain to us, have you had some cases, Aquino & Lowe Law Firm, have you had cases that concern this?
Absolutely. Like I said, this is a common situation, and so the good and the bad is that we have lots of experience as far as these cases are concerned. And the analysis really depends on who the petitioner is, whether it's a family-based petition, employment-based petition. The good news is that in the past 2.5 years, we have seen that immigration is interpreting the law very liberally, very much in favor of immigrants, and so a lot of people are definitely benefiting from this law.
Okay, so when you say, and we're going to be talking about that, let's say, for example, a petitioner and beneficiary are husband and wife, but you mentioned earlier, and use this if you need that for your analysis and explanation, when you say immigration is interpreting the law a little bit more liberally or leniently, why is that? What are the choices? How have they interpreted the law before?
Well, it's not so much choices. Like in any law, you have various interpretations. I can read it one way, immigration can read it one way. And so when the law first came out about 2.5 years ago, we weren't quite certain, the private bar wasn't quite certain how immigration was going to interpret that, whether they would interpret it so strictly that it would only apply to a few people. And so a lot of that may be the individuals who are interpreting the law, what the stance of immigration is at that time. And so that's why I say, thankfully, immigration has interpreted this particular law in a very favorable fashion.
All right, now let's explain this. Petitioner and beneficiary are husband and wife. What does that mean?
So if the petitioner is a U.S. citizen spouse, this is just certainly the most favorable category to be in. If a person is a widow, pretty much you should be getting your green card even if your U.S. citizen spouse passes away, because primarily all that you really need to prove is that the marriage between the two of you was legitimate and bona fide.
Okay, so marriage certificate?
Well, marriage certificate is one. That's the starting point,
right? You
know, because that's easy.
Yeah.
What you do need to show is the fact that the relationship was entered into, it was a real relationship, you really were in love with one another, and it wasn't just for immigration. And so in the other categories, there are added requirements. With a widow, there's no issue regarding where the person is. There's no issue regarding affidavit of support. Really, all of those issues are kind of swept under the table, and really the only issue is, was this a real relationship?
All right. What about the other categories? Let's say, for example, other family-based categories.
So with the other family-based categories and also with the employment-based categories, the question there becomes really whether this new law known as 204L, whether that applies or not. Okay, because if it applies, it makes the ability to obtain your green card a little bit easier than if the 204L does not apply.
And one of the main considerations is whether the petitioner was living here in the U.S.?
Yes. Under 204L, it would apply if the petitioner were domiciled here in the U.S. And I say use the term domiciled because it doesn't necessarily mean the person died in the United States.
Oh, okay.
They could have died in the Philippines, for example, but you do need to show that the U.S. was their permanent residence.
Does it also matter whether the person being petitioned was physically present in the U.S.?
Yes. Under the 204L analysis, in order for a person to qualify, at least one of the beneficiaries must have been here in the United States. So it doesn't have to necessarily be the person on the petition. It could be one of the children, or it can be the spouse. As long as one of those individuals are here in the U.S., then the more favorable 204L applies, and it makes the case that much easier.
And there's one requirement here that wasn't required earlier, which, as you mentioned, for the husband and wife petitioner beneficiary category, affidavit of support.
Right. And that is a problem for a lot of people, because if the petitioner passes away and it's not the widow category, you do need a qualifying relative to submit a substitute affidavit of support.
Oh, okay.
And so even though you might fulfill the other requirements about physical presence, unless you have an affidavit, a person who can qualify for that substitute affidavit of support, you can't proceed. The only other exception to that is if the person can essentially be exempt from the affidavit of support requirement. So if they're in the U.S. working, have 10 qualifying quarters with Social Security, then they're exempt.
And we just talked about the requirements for 204L.
Exactly.
But if you don't qualify or you don't meet the requirements, you still shouldn't despair. There's still hope for you, because there is such a thing as HR, or humanitarian reinstatement. But that should be for another topic, maybe. But I hope we were able to enlighten you today on the show. Thank you so much for explaining those things.
Always a pleasure.
The best thing is consult a lawyer. And Aquino & Low Law Firm, they do give consultations. That's the number to call on the screen if you want to schedule your appointment now. Also via email, they do that. Also phone consultation for a nominal fee. For now, thank you so much, and
Thank
more
you.
power. We'll be back more in Kababayan LA. Don't go away.